Hello everyone, Mehran Fardis here with Care Law Group. I'm an immigration attorney in San Diego, California. Finally some sun today in San Diego after a while of cloudy weather. We discuss immigration issues in this channel about a variety of topics. I practice law in the state of California and immigration in all 50 states of the US and all across the world. With any immigration questions you have or pending matters, issues, we're here to assist. Today I wanted to discuss something very important, and that is marriage of a US citizen to a non-US citizen when the non-US citizen beneficiary has entered US illegally. Basically, illegal presence in US, meaning coming across the border without a visa or any type of admission into US. This situation does apply to quite a few people. People have come into US through various means. Sometimes people that come through the border to seek asylum are entered, basically paroled, allowed to come into US, but they're not legally admitted. This means they're not really legally inside US. So even if a US citizen marries a spouse who is inside the US, having come through the border, being basically questioned by the Border Patrol, that person still is not an actual person who is admitted into US or inspected under the definition of the USCIS immigration meaning. An admitted person is somebody who has been checked in and has come into US legally. So the way the process works is that when there is marriage or any type of petition from a spouse to the other spouse who is not in US legally, this process happens in 3 steps. People often think when you marry a US citizen, you can simply file and then they'll get their green card. This happens first by filing the form I-130 and I-130A inside US. You basically pretend or proceed as if this matter were for someone outside US via consular processing. So the US petitioner files I-130, I-130A plus supporting documents. We wait for USCIS to approve this petition. Once it is approved, then we file for the second step, which is consular processing, meaning for the non-US person to have the interview outside US at a consular or embassy. However, if the person inside US leaves US to go out to have the interview, they are not able to come back into US because they've entered illegally and they've been in US for most likely more than 180 days. So they're most of the time subject to a 10-year bar, sometimes a 3-year bar, most of the time a 10-year bar. So to avoid the person leaving US being subject to a bar coming back, the US petitioner will file a waiver, a 601 waiver, along with the request for consular processing when the USCIS has approved the I-130. The waiver is a lengthy document basically requesting USCIS to waive the requirement or the bar for the person so that the person can go out, have an interview, and come back. We process quite a few of these waivers these days, and they do take quite a bit of time. They took about a year and a half last time we processed it, and this happened a few weeks ago. If the US spouse is a member of the military, there is no need for the beneficiary, the non-US person, to leave the country. This is called the parole in place. There is also another exception called 245I, which basically for people who have entered US prior to year 2000, they don't need to leave US. But these are 2 narrow exceptions. Most of the time, these 2 don't apply and the beneficiary does have to leave US. So when someone is inside US who has entered US illegally or has come through the border but not been legally admitted or inspected by Border Patrol, we first have to file the I-130. It needs to be approved. It takes about 4 or 5 months right now to be approved. Once it is approved, we request consular processing and explain to NBC at that time that this matter requires a waiver, so NBC doesn't give you a visa before the waiver is approved. NBC waits for the waiver to be approved, the 601 waiver to be approved, and then NBC provides a visa appointment. The beneficiary can go to the consulate or embassy a few days prior to the visa appointment, have the interview, get a visa, and come back to US. That's how this process is handled. If you have any questions about this matter, contact our office. Again, Mehran Fardis from San Diego with Care Law Group Immigration Attorneys here to answer your questions, concerns, issues about any immigration related matters. Please like the video if you did, share it with your friends, and contact our office for any questions you may have about any of your immigration related matters. Have a great day. Talk to you soon.